Hello, and welcome to Self-Evident Truth with the Grumpy Old Vet, episode 20. Um, some things we need to discuss and talk about. This one is going to be titled The Slow Chains of Tyranny. How slowly the chains are built. Sometimes the chains are built in 4 years, and they're built fast. Trust me when I say that evil things can be done by good people with the best of intentions. Our founders understood that. They understood the natural nature of man and what they put in the Constitution and the principles that they put in the Constitution are very important. Probably even more important than the words themselves are the principles. And they understood through history how the chains of tyranny are forged very slowly. Sometimes they're forged within 4 years. We're going to look at a few things here and we're going to break them down and analyze them and see what you think. Now, let's look at specifically the right to keep and bear arms, what people call the Second Amendment, which is really the second article of the Bill of Rights. The Bill of Rights was one document added to the Constitution, and it had it had 10 articles in it. The second article is what's known as the Second Amendment. And the Second Amendment to the Constitution of the United States Bill of Rights, Article 2, or Amendment 2, is what more people understand it as, states a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Now, Michigan, because it has to be in pursuance thereof, the federal Constitution, it has to have something in spirit and form the same. So let's look at what the Michigan Constitution says. The Michigan Constitution of 1963, Article 1, subsection 6, says bearing of arms, section 6, every person has a right to keep and bear arms for the defense of himself and the state. So you can see it is in spirit and form the same, right? It's pursuant thereof the federal Constitution. And so this is the Michigan Constitution that gives us the right to keep and bear arms. One of the first things we have to look at is how our Constitution, which is under Article 6, Section 1, Clause 2, the supreme law of the land. And for anything else to be a supreme, it has to be made in pursuance thereof, which means it has to be in spirit and form the same. And so our federal Constitution is the supreme law. And for the Michigan Constitution to be as supreme, it has to be made in pursuance thereof. So our federal government is broken down into three separate and equal branches of government: the legislative, the executive, and the judicial. Each one of the three has their own individual powers and responsibilities. So let's look at the Constitution, Article 1, Section 1. It says, all legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and House of Representatives. Okay, so that's the federal Constitution. Now let's look and see what the state Constitution says. Michigan Constitution of 1963, Article 3, subsection 2, separation of powers in government. Section 2 says the powers of government are divided into three branches: legislative, executive, and judicial. No person exercising powers of one branch shall exercise powers properly belonging to another branch except as expressly provided in this Constitution. Okay, so it establishes that the legislative branch creates the law. And in the Michigan Constitution, it goes a little farther and it says no other branch can usurp the powers given to an individual branch by the Constitution. In fact, if you remember, in October of 2020, the Michigan Supreme Court even said that Governor Whitmer didn't have the powers to do what she thought she had the powers to do, because the legislature, years past, during an emergency, had lent her the legislative power. And the Supreme Court said, no, there's not a branch of government that can lend their power to another branch. See, the way the Constitution's written is, if that power isn't specifically given by the Constitution, then they don't have that power. See, it's the Constitution enumerates power, and you can't, the legislature, the judicial, or the executive cannot go outside that. They only have that power granted to them by the Constitution. This is what's known as a limited government. Now let's take a look at some of the firearm laws in Michigan. One of the things I'm going to put up here is the Michigan State Police Legal Update, number 86, published on October 26, 2010. Okay, it says firearm laws. It has some categories such as open carry of firearms. Then it goes into Michigan Compiled Law 750.234D. Then it goes into Michigan Compiled Law 750.226. Then it goes into brandishing firearms, what that is under Michigan Compiled Law 750.234E. The transporting of firearms. Then it goes to page 2, carrying a concealed weapon. And then Firearms Act of Michigan Compiled Law 28.422. Then it goes into the section of out-of-state residents, non-residents concealed pistol possession, and so the update is 3 pages. And this is very important. The Michigan State Police put it out so that they could comply, and their officers could comply with both the federal Constitution, the state Constitution, the laws promulgated by the Michigan legislature in pursuance thereof, case law and also with case law presented by the Supreme Court of the United States. And so there's a couple of cases with the Supreme Court of the United States that are brought out, and 2 of them are DC versus Heller and NYSERPA versus Bruin. And we have to look at these 2 and break it down to see what the Supreme Court said. What's the litmus test on any law that any legislature would create, and making sure that that law stays within the Second Amendment of the federal Constitution. Because remember, the state Constitution has to be pursuant thereof. So let's look at a couple of things that Heller brings out and Bruin brings out. So what we have to look at is what DC versus Heller. Let's look at that decision first. That case revolved around them, Washington, D.C., trying to ban the residents of Washington, D.C. from keeping and bearing arms, from being able to have weapons. And it went all the way up to the Supreme Court. And the Supreme Court said that, well, we have to look at the text of the Second Amendment. And in the text of the Second Amendment, words have meanings. We have to define those words. So they defined that keep of the keep and bear arms. Keep means to possess, and bear means to carry. So if any law hits the simple text of the Second Amendment, then the Second Amendment is implicated. Now, Bruin brought us the methodology and how we have to look at any Second Amendment law or any law that would be on firearms. So basically, under Heller, if the plain text of the Constitution is implicated by that law, then the person who is taking this to the Supreme Court, they've met their burden. So once the law or anything that they are contesting, that the legislature of any area has put into place, if the Second Amendment is implicated by the plain text, now the burden shifts. So once the individual proves the burden that the plain text of the Second Amendment is implicated, the burden shifts to the government. Once the burden shifts to the government has an obligation to show where our founders at the time of the Second Amendment was ratified, 1791, that there was historical analog laws in place that supports this new law, that supports the legislature in this new gun law. And so that's the Bruin methodology. So there's the Heller case that defines what keep and bear arms means. It means to possess and to carry. And then once the individual has implicated the plain text of the Second Amendment, then the burden shifts to the government to prove that there was historical analog law in place at the time of the founding, at the time of the ratification of the Second Amendment that would support this new law. That's called the Bruin methodology. Now with that, a lot of times what they try to do is they try to bring up laws from 1870 and the beginning of the 20th century, and it can't be that. It has to be a law from the time of the ratification of the Second Amendment. Because remember, the Constitution is a contract, or better known as a compact. And so thereby it falls under contract law. So anytime there's a dispute of what the contract means, we have to go back to what's called the meeting of the minds. What did it mean at the time? What did the people who put it in place, what did they intend, and what was the simple meaning, the principles behind why they did what they did? Let's go through some very specific areas of the Michigan State Police Legal Update number 86. We're going to concentrate on a couple areas there. One of the ones is the open carrying of firearms, this section right here. In that section, it says, in Michigan, it is legal for a person to carry a firearm in public as long as the person is carrying the firearm with lawful intent and the firearm is not concealed. You will not find a law that states it is legal to openly carry a firearm. It is legal because there is no Michigan law that prohibits it. However, Michigan law limits the premises on which a person may carry a firearm. Okay, that brings us to the next section that we're going to focus on, and that's Michigan Compiled Law 750.234D. 750.234D provides that it is a 90-day misdemeanor to possess a firearm on the premises of any of the following: a depository financial institution, a bank or credit union, a church or other place of religious worship, a court, a theater, a sports arena, a daycare center, a hospital, an establishment licensed under the Liquor Control Code. Now, The above section does not apply to any of the following. Now, this is important. The owner or a person hired as security if the firearm is possessed for the purpose of providing security. A peace officer. A person with a valid concealed pistol license, a CPL, issued by any state. A person who possesses on one of the above listed premises with the permission of the owner or the owner's agent. So that's 750.234D. Okay, that's one of the sections that we want to look at. Now, if we go to page 2, under Firearms Act, we're going to go over to the second column, and we're going to look at Michigan Compiled Law 28.425O. Provides that a person with a valid CPL shall not carry a concealed pistol in a pistol-free zone. First offense is a state civil infraction. The following is a list of the premises excluding parking lots included in the statute. A school or school property, except a parent or legal guardian who is dropping off or picking up a child and the pistol is kept in the vehicle. Public or private daycare center, sports arena or stadium, a bar or tavern where sale and consumption of liquor by the glass is the primary source of income, does not apply to owner or employee of the business. Any property or facility owned or operated by a church, synagogue, mosque, temple, or other place of worship, unless authorized by the presiding official. An entertainment facility that has a seating capacity of 2,500 or more, a hospital, a dormitory or classroom of a community college, college or university, a casino. Now we have to look at the note here. It says, note, the above statute applies to CPL holders carrying a concealed pistol. If the CPL holder is carrying a non-concealed pistol, the statute does not apply. As noted above, the unlawful premises listed in Michigan Compiled Law 750.234D do not apply to persons with a valid CPL. Therefore, a person with a valid CPL may carry a non-concealed pistol in the areas described in Michigan Compiled Law 28.425O and Michigan Compiled Law 750.234D. These are important parts of the law. Now, let's do a little analysis of what's going on in Hillsdale. For many years in Hillsdale, we were able to carry our weapons into the court because there were other offices there, other county offices there. And there was a couple of times they tried to ban guns there, but the people stood up and said, no, we're not going to have that. And so they rescinded that. Well, in recent history, they've moved all of the offices, all of the county offices, over to 33 McCollum Street, except for the county clerk's office. Now, the county clerk's office, they're the clerk of the court. However, they do many, many more things. And so there are people that go in there and go to that office, probably more than court business. People of the public go in there to do different things. Marriage license, filing paperwork, getting paperwork under the Freedom of Information Act, filing affidavits of identity to run for precinct delegate or to run for office. There's many dog licenses. You have to go there for your dog license. You have to go there to apply for your CPL. So the bulk of their business deals with the public that isn't involved in courts. Now, of course, they are the clerk of the court, so they do handle all the court business there as well. But the bulk of the people that come into that courthouse to go to that office are not going there because of a court issue. They're going there because that's the office that they need to go to get things done. And now we've already established that they have a Second Amendment right to keep and bear arms. And we've now also looked at what the state constitution says in Article 1, Section 6. Now we've looked at the Michigan compiled law. So remember, we started this out with the chains of tyranny are forged slowly. And they're done slowly so that the people don't realize that the chains are being forged on their ankles and wrists, but they are being forged. And this is the whole reason for a sheriff. The sheriff takes an oath to defend the rights of the people. The sheriff has two constitutional obligations. One is to maintain a jail, and the other one is for court security. They don't really have a constitutional duty to bring in revenue through regulatory law, but they do take an oath to the Constitution of the United States and the Constitution of the state of Michigan. Now, going back to something Lord Acton said, and that power corrupts, and absolute power corrupts absolutely. Sometimes those chains of tyranny are forged in a 4-year period. So let's look at some of this. I'm sure you all will recognize this picture that was of our sheriff in just in August of 2024. Let's take a look at this combat uniform that our sheriff is wearing. It's quite a stark difference from October of 2020. Let's go through it, and we're going to get into just this one specific area of guns in the courthouse, and we're going to look at what the chief judge has to say about it, and we'll look at what the principle of the law is under Heller and Bruin, and we'll look at the Heller decision and the Bruin ideology, and we'll look at what the sheriff has to say about it as well. Now, here's a short clip of what Chief Justice Lisney had to say in October 27th of 2020. You can find this on the on the Hillsdale County, Michigan Board of Commissioners YouTube channel, and it's under 20201027. So that's October 27th, 2020. Here's what Judge Lisney had to say.
First of all, in response to Mr. Tan, I find myself in the position of agreeing with most of what he said. I don't disagree with what he had to say. I would not be here before you if I didn't have legal authority to do so. I simply wouldn't do that. And in fact, I would quote to you, not to get too technical here, but there is a Supreme Court order that's a United States Supreme Court order that supports exactly what we're talking about here, and that's District of Columbia versus Heller, 554 U.S. 570. It's a 2008 case. I take that very seriously. Mr. Commissioner Caswell, if you saw a sign, it wasn't at my direction. It was and I looked at Judge Bianchi, as we agreed that the sign was taken down and not put back up. The only sign that was up after our agreement was the one at the district court, as we discussed. So I have no knowledge of any other sign that has been replaced. So if that happened, that didn't happen because of my say. As I've established in my tenure on the bench, which isn't long, 6 years, I am a rule of law judge. Non-compliance with these materials would be illegal. Since 2001, it has been established that weapons are not permitted in any courtroom, office, or other space used for official court business or by judicial employees unless the chief judge or other person designated by the chief judge has given prior approval consistent with the court's written policy. This rule was established by the Michigan Supreme Court in Administrative Order 2001-01, as alluded to by Mr. McDonnell. This has been in effect and unchallenged for nearly the last 20 years. The Michigan State Police website references this order in its section on firearms and prohibited premises. It remains the law that must be followed. The Michigan Supreme Court required each county in Michigan to adopt this policy. In 2002, Hillsdale County complied with this requirement and adopted Local Administrative Order 2002-01. It is signed by all three of our judges at the time, Judge Smith, Judge Sanderson, and Judge Nye, signed on February 12, 2002, reading as follows, and you have it there in front of you, but I'm going to go ahead and read it for the benefit of everyone. This administrative order is issued in accordance with Michigan Supreme Court Administrative Order 2001-01. The purpose of this order is to address the presence of weapons in court facilities. It is ordered, 1. No weapons are allowed in the courthouse, courtroom, office, or space used for official court business or by judicial employees. This prohibition does not apply to court security personnel in the performance of their official duties, law enforcement officers who are transporting prisoners or who attend court as a witness in a criminal proceeding, or to members of the judiciary who have been issued a concealed weapons permit. The Chief Judge may authorize additional exceptions in extraordinary circumstances.
Now remember, we've already covered Article 1, Section 1 of the U.S. Constitution that says all legislative power is granted to the legislature. So all of the power to create law is given to the legislature. And we've looked at the state constitution that basically is pursuant thereof the federal constitution and says the same thing. Now, if you remember, in October of 2020, our own Michigan Supreme Court said that the legislature cannot lend their power to any other branch of government, not to the executive branch, nor to the judicial branch. But yet, Judge Lisney cites a Supreme Court opinion or an order stating that the chief judge can promulgate these rules of weapons within the court. Seems to me that a Supreme Court opinion doesn't make law. The law is still created by the legislature. And we've just gone over Michigan Compiled Law 750.234D and Michigan Compiled Law 28.425O. Both laws created by the legislative branch of government in Michigan. Okay? Now, we won't even get into the debate whether it's pursuant thereof, the state constitution, federal constitution. We won't even get into that. Let's just look at those two laws created by the legislature. So we've got that. Now, let's look at Judicial Canon 2, Section B, and we'll look at Judicial Canon 3, Subsection 1. I'll put these up for you right now. These are very important. Now, if you will, look at the highlighted area here. Michigan Judicial Canon 2, a judge should avoid impropriety and the appearance of impropriety in all activities. Let's look at B. B says a judge should respect and observe the law. Well, where does the law come from? Well, we've already established under the federal constitution, state constitution, the law comes from the legislature, not from the authority of the Supreme Court. Supreme Court doesn't make law. They don't have the authority to usurp the lawmaking powers of the legislature, and so thereby their opinions are only opinions. But the judges, the judicial branch, still has to follow the law. Now let's look at Michigan Judicial Canon 3. A judge should perform the duties of office impartially and diligently. Let's look at subsection 1. It says a judge should be faithful to the law and maintain professional competence in it. So, our chief judge should know that only the legislature makes law. And what she was citing in October of 2020 was judicial opinion. That judicial opinion is not law. She's honor bound to follow the law. Now, let's look at the sheriff and what he had to say. Pay particular attention to his uniform. Now, this is right after he took office. This is right after Tim Parker quit, and they swore Scott Hodshire in as sheriff. Look at his uniform. It didn't look like a combat uniform, did it? It looked like a professional law enforcement uniform. Dignity. But remember, in August of 2024, when he went to stand next to the president in the president's rally in Grand Rapids, he was dressed in a combat uniform, BDUs, battle dress uniform. In 4 years. In 4 years, we went from a professional looking uniform, which is something he probably should have worn when he was up meeting the president and having his picture taken with him, rather than a battle dress uniform. So these chains of tyranny happen very slowly. Now, the sheriff is going to say that he believes in the Second Amendment, but he's going to agree with the judges 4,000% and in a judicial order and not the law. The people are the final arbiters of what is and isn't constitutional. In fact, that's the very principles of our founding. It's the people. It's not a Supreme Court, either a state or a federal. It's the people themselves. And how do we do that? Well, one of the simplest ways we do that is through a vote. We vote. We vote for people that understand these principles, can read the law, articulate the law, and can follow the law as it pertains to the principles. So let's take a second and look at the sheriff's remarks.
I agree 1,000% with Chief Hepner, and I agree 1,000% with the judges. It is my duty as the sheriff to provide security for the employees of the courthouse. I do not have the resources to put 5 of my men in the court systems to search for weapons. Everybody's entitled to a safe place to live and a safe place to work, and as my job as the sheriff, I have to provide that place. We house rapists, murderers in the Hillsborough County Jail, and it's my job to also protect them when being shuttled back and forth into the court systems. Most of the inmates know when their court date is. It would be very easy for them to get on the phone and call one of their buddies and say, bring a gun into the court systems, and it'll be over with then. It's not if it's going to happen, it's when it's going to happen, and we want to prevent that from happening. I'm pro Second Amendment, like Chief Hepner stated that everywhere else in Hillsborough County, I'm great with having a weapon, being able to carry it in this building as well. I do believe that the security of the courthouse is very important.
So in conclusion, it's pretty simple. The chains of tyranny have happened very quickly in 4 years. We went from a professional uniform to a battle dress uniform. We've gone from a professional paramilitary law enforcement uniform to a combat uniform. My question is, who are you in combat with? And we've got a chief judge that wants to rely on Michigan Supreme Court opinions rather than following the judicial canons that she's required to follow in keeping with the law. So those judicial canons say that she should follow the law, that she has to be mindful of the law, and she has to look at that. Now she brings up Heller, the Heller decision, but with Heller, you have to look at the Bruin ideology. All right. Plain text, once the plain text is implicated, then it's on the government to show historical analog law that was in place at the time of the founding that supports that. Now, there are some historical analog laws that would support not having guns in the courtroom. But should we disregard the Constitution and the law because it doesn't fit our need? Or should we change the law so that it's appropriate to what we needed at the time? See, my thing is, if the law is not appropriate, then we change it. We don't disregard it, or we don't decide one day to use judicial opinion and then another day to use the legislative law. See, this varies from the principle that we need. And when we vary from the principle, what happens is we have different opinions based on however we feel that day. And we shouldn't be doing our courts by how we feel, and we shouldn't be doing our law enforcement by how we feel. They should be done on the strict principle of the founding of our country and based on the law. And if the law is not in compliance with the principle, then we need to change it. That's simply what it is. It was Abraham Lincoln that said we shouldn't try to overthrow the Constitution, but to overthrow those men that would try to overthrow the Constitution. So the Constitution is important, and the principles of the founding are important. Our laws are changeable, and we should change those laws if they don't fit the principle. Or if they're not working for what we need them to work for, then we need to change the law. But that comes down to the people. And the easiest way to do that is in the vote. Now, August 6th, you're going to get a chance to vote. Do you want a sheriff that has gone from professional uniform to a combat uniform and agreeing with the judiciary 4,000% instead of understanding the oath that he took and the principles of the founding and advocating at a podium that, well, this is what the law says. I don't disagree with what the Chief Justice says, and I understand the principle behind what the Chief Justice is talking about. However, the Supreme Court, their opinion doesn't make law. We've got a law on the books that we have to follow, and if we don't like that law, then the judge and the executive department should petition the legislature to change that law to go along with the opinion of the Supreme Court of the state of Michigan, if that's what's necessary. But see, that doesn't happen by itself. That happens with we the people. One of the easiest ways to determine what the consent of the governed is through a vote. That's one of the easiest ways. Now in Hillsdale, all those decisions are made in the primary, August 6th. So I encourage everyone, get registered to vote and vote in the primary of August 6th. Vote who your chief executive of the county needs to be. Do you want someone that's running around in battle dress uniform, agreeing with the judiciary 4,000%, rather than jealously guarding the power that's been granted to the executive branch of government through the Constitution and speaking reason and logic to the issue? Or do you want somebody that's just going to go along to get along, be part of the good old boys? You know, as long as you're part of the cool kids section, then it's whatever they say. See, I happen to think that we need to have a chief executive that understands the principle of the founding, understands the law, understands Heller and Bruin, and then enforces the law appropriately. You make that decision. That's going to be made on August 6th. So with that, God bless Hillsdale, and may God bless the United States.